It just depends. I mean, I prefer for that already to be resolved before I file, but sometimes that's just not. Sometimes the circumstances require that the bankruptcy is filed to get the automatic stay. It could be that they're behind on their vehicle for several months and they need the protection of the automatic stay. So in those cases, that's something that you really need to discuss with your attorney personally. But in those cases, yeah, the divorce can continue. By the way, determining how much child support one would have to pay, that isn't stopped by the bankruptcy. That can go forward. Perhaps the division of property, maybe that's probably the only thing that I can think of that might be stayed during a bankruptcy. But it is definitely a complicated issue. There are a lot of legal consequences that may arise in a bankruptcy with respect to this family law issue. And I think that would take several hours and more expertise than I can offer today on that issue. So you really need to talk to your attorney concerning family law problems and bankruptcy.
Well, you're listening to Joel Gonzalez on bankruptcy. You can contact him for further questions, 361-887-6363. In the words of my favorite actor, Denzel Washington, in Training Day that he got an Academy Award for, he said, "It's chess, not checkers," when you're talking about bankruptcy, and that's why we have Joel Gonzalez on here. Okay, we've talked about the automatic stay. We've seen what is exempt, non-exempt. We've also seen the differences, like what's credit card debt, what is good. Now let's talk about Chapter 7, the straight bankruptcy, versus Chapter 13, which you've been, I'm reading between the lines here. You're a big supporter of Chapter 13 versus Chapter 7, and why is that?
Well, I like them both, but yeah, I think that Chapter 13 in a lot of cases is a better option. In most cases, you risk less challenges from the trustee's office, especially if we're talking about a borderline case where you're right at the cusp of the income level where you might be above the median income, and when we calculate the means test, we're at the maximum level on the expenses that are allowed by the IRS, because we have to calculate, we determine expenses, and the IRS provides guidelines. If you're at the level where you're almost exceeding those guidelines, then you're almost inviting a challenge. So in a Chapter 13, you can have a Chapter 13 where your Chapter 13 payment might be $50 or $100. I mean, there's nothing against that. If that's all your disposable income allows, then that's all the payment's going to be. And if that's legitimately what it's going to be, nobody's going to object to that.
Okay, and we were going through our anatomy example of bankruptcy. We walk in there, they have the creditors meeting. That's the preliminaries, right? Once you file your bankruptcy, everything stops, for the most part, automatic stay. The creditors meeting, this guy owes me or this guy doesn't. If it's so little or they know that the person can't pay, like in our elderly example, in many instances, they're not even going to show up. But let's say that it's not the case and the person's thinking of Chapter 13. You mentioned a trustee. Who is this trustee?
Well, in the Southern District of Texas here in the Corpus Christi Division, it's Cindy Budlash. She's actually here in this building, Joe.
Oh, really?
That's the Chapter 13 trustee. So maybe her ears are burning right now.
I know. I mean, but we're saying good things, though. Trustees are good, right?
She runs a great organization. If we have a situation where there's a little bit of money to pay, generally, again, if it's a Chapter 13, because it is a repayment plan and the creditors aren't going to show up at the 341 meeting, it's very rare. Usually what happens is they have to file what's called a proof of claim. That's sort of their way of saying, hey, this is what the debtor owes me, this is the value of the claim, and this is what the total outstanding claim is. If there's enough money to pay, if it's an unsecured item, it's paid in order of priority. The unsecured items are the last priority. That's, if there's not enough payment or not enough money to go around, it doesn't get paid. And that's just the way it works. And the reason for that is, in a Chapter 13, the debtor must pay at least the same amount that he would have paid in a Chapter 7. For example, earlier when we talked about unexempt assets, suppose we have a boat, and I'll just make this example up, and it's worth $6,000. No, let's just say it's worth $20,000. Well, let's just say the Texas exemptions allow you to exempt a boat that's worth $5,000. So we have $15,000 of unexempt property, right? The policy reason is the creditors should be no worse off in a Chapter 13 than they would be in a Chapter 7. Because in a Chapter 7, there's so much money that's unexempt. So that could be sold and distributed among the creditors.
Okay.
So in a Chapter 13, the debtor would have to pay at least the same amount as the unexempt assets, provided there's enough disposable income.
Well, and that's a good example you use. The boat example and the non-exempt and exempt, there's a certain amount that you can go up to. Now, a lot of people have asked this question, and one of the issues that they've asked about is they've asked me, Joe, I mean, how much can I keep if somebody's suing me like a creditor, or I have a liability insurance and I hit a brand new Mercedes-Benz that's $120,000 and a neurosurgeon is suing me and he also has personal injuries exceeding $50,000. I mean, I'm drowning fast. Yeah. You know, can the example where somebody's suing for over 100 grand and you know, they may get a judgment against them in court, the person knows that they've got a judgment against them, can they file bankruptcy and have that judgment stayed?
Yes, they can. And we have to be careful about this. If we're talking about somebody who was intoxicated and they were driving, and we're talking about criminal penalties and criminal fines, that is not dischargeable.
Okay, I'm glad you brought that up.
I think the organization MAD were very successful in their lobbying with Congress, so they passed exceptions to the discharge, and some of that is personal injuries that were caused by someone who was driving a motor vehicle under the influence of alcohol or drugs. But if it was just strict negligence, you know, I made a mistake, it was an accident, I'm being sued, I don't have this money, I will never have enough money to pay that judgment, then that's typically considered just a simple unsecured judgment against you, and it's treated like a credit card.
And so when they filed that and the judge in the district court said, you're going to pay 200 grand back to this neurosurgeon or whatever and buy him a new Mercedes, and then the guy says, what? I can't pay that? This guy sued me, and you know, a good attorney like William D. Bonilla perhaps gets that, and then the poor guy that has maybe $20,000, $25,000 in just liability insurance files bankruptcy. Then, in other words, even though it's a judgment from a court, they got to get in line too.
They have to get in line. They have to file a proof of claim, just like any other credit card company, just like any other unsecured debt. And if there's not enough money to pay during the life of the bankruptcy, or in this case, I mean, they could even file Chapter 7 bankruptcy, and if they qualify, typically within 5-6 months, they can get their Chapter 7 discharge, and they get a new financial fresh start.
Well, and we've looked at, first of all, we've looked at the anatomy of bankruptcy in this segment. In the past segment that we're talking about, we found out just what exactly bankruptcy is, how to go about filing, what are the things that need to be done before you file bankruptcy. And if you've missed it, we're going to air this several times here in San Antonio and Laredo. And then you can go to www.youtube.com and you can type in South Texas Crossfire bankruptcy, and that'll come right up. And you're listening to Joel Gonzalez. You can reach him at 361-887-6363. In the latter half of our segment, I know that you wanted to discuss a particular issue on bankruptcy beyond the automatic stay. Now let's go through the whole anatomy of it. You've got the automatic stay in place. You had the creditors meeting. Everybody knows what's on the table. Does the person that is filing for bankruptcy, do they get a list of all their assets? Do they put that together? How does that work?
Yeah, that's actually typically what most attorneys, bankruptcy attorneys, would ask the clients. Well, first of all, you need to get that certificate of credit counseling. You'll need to obtain your tax returns for the past 3 to 4 years. The means test requires that we calculate your income for the past 6 months. So I require that they provide me with pay stubs so I can clearly see what their income for the last 6 months was. In addition, any judgments against them, and we go through the petition together. And of course, a list of their assets and a replacement value. So once we file, before we file, I mean, we make sure that that's what it is. We go over it with the debtor. Once the debtor certifies it, he'll sign a declaration page so that under the penalty of perjury, he declares that all of the information in the petition is true and correct. And we go forward. We go to the creditor meeting. What they can expect at the creditor meeting, like I said, usually creditors, they don't show up. But the trustee or the trustee's representative will ask questions.